Hello and welcome to Neeti Ravaz, your to be favorite podcast of the day that aspires to inculcate policy discussions into our mainstream tradition. So grab your cup of coffee and beware, because you might just lose track of time. Today we have convened to discuss about women in law and justice machinery. We are joined by Nimisha Priyankari and Abhishek Singh. They have done their law from SIL Allahabad and they are currently registered advocates at the High Court and they are practicing at the Allahabad High Court. Abhishek Singh holds his focus and his interest in geopolitics, international law, and criminology, while Nimisha holds her interest at the interplay of constitutional law and sociological perspectives. Hello, Abhishek. Hello, Nimisha. Welcome. Hi. So we have convened today to discuss about women in law and justice machinery. Nimisha, you being a lawyer in your own right, and Abhishek, you too. But I would hold Nimisha's credentials more important because she's also a woman, and here and she has first-hand stakes in this discussion. So welcome to both of you. As we go ahead, I would want you all to trace for me the official statistics that exists presently that tells us about the share of women in judiciary at different levels, at the subordinate courts levels and at higher courts, the high court and the supreme court. And how has this scenario changed in the last few decades, if any? Yeah.
Okay, over the last few decades, women have acquired so many good posts in our judiciary, and to be honest, the statistics are that women constitute of 37% at this district levels, and about 14% or something at high court. I mean, at that high court levels, and surprisingly, at the Supreme Court, we just have one women judge out of the 33 sitting judges.
Right.
So we can see that as we are going up the hierarchy, the number of women is decreasing, right? But I would also like to say that there has been a slight increase over the past decade. Yes, I agree with my colleague, Mr. Mishra, because as I have seen, as I've gone through the few databases like the Department of Justice, as of 2009 to 10, the figure of the contribution of women in the judiciary at district judiciary level, at subordinate judiciary, it was around 27% or something. But by the time we came to 2023-24, it came up to around 36 to 38%. That was around 9 to 11% of jump for 15 years, which is not much significant, but yes, it is a steady change, so we should be appreciating it.
Right.
While on the other hand, in the high courts, as Nimisha already stated, that as of 2024, it is around 13 to 14%, while as we date back to 2010, that as I was stating earlier, it was 8 to 9%. There is a growth, but it is slow and shallow. While in the Supreme Court, that is a concerning issue that only one woman judge is presently and there among all the sitting judges. So that is a concerning issue, but we'll see what happens. But it is sort of progressive.
Yes, you're right in talking out that the numerical minority of women in these different hierarchical levels, it definitely represents a representational imbalance that exists in the justice machinery in India. We'll go on to talk about why is there such a steep drop in women's representation from the lower judiciary to the higher judiciary. What kind of problems, what kind of issues exist, and what is the nature of this problem?
Well, as far as my interpretation goes, where as we just saw that in district level, district courts, the contribution of women, the proportion of women is significantly higher than what there is at the higher judicial levels. So, what I think that where there is a case of competitive exams like district courts, that's the entry level. Over there, the women dominate. They enter in significant numbers. While when we come to the higher levels where there is discretionary appointment systems, like in the high courts, supreme courts, the women's presence it collapses sort of. So the pattern is consistent and statistically significant, but it is I suppose it is a structural filter that happens over there, like the collegium-based selection takes place in the Supreme Courts and High Courts, Supreme Court and High Courts. I mean, so there is no published criteria for the collegium. There is a very heavy reliance on visibility on the constitutional litigation, senior advocacy networks, informal reputation, and all these. These spaces are historically male dominated. So that might be a reason why women are disproportionately portrayed in these levels. Also, the transfer and mobility expectations, where the women judges are disproportionately declined elevation due to family location constraints, spousal employment, and also children education, and all these. These are the factors that are significantly affecting the portrayal of women in the higher judicial level. For decades after independence, Aditi, women were largely absent from the courtrooms. And surprisingly, there was a male dominance. We could clearly see. And even like after many years, almost like 20 years or something, women were still not there, but yet women persisted. So I would like to name the first women lawyer who was in India, Miss Cornelia Sorabji, and then we had our first women judge in the Supreme Court, who was Justice Fatima Bibi. Then Leela Seth, the first women Chief Justice of High Court. Then women slowly started entering this profession, and which was actually not designed for them, but they reshaped them in some manner. So the evolution was very outstanding.
Thank you for replacing the word revolution to evolution, because the speed of the change is not quite revolutionary. Yes, it is definitely evolutionary.
Evolutionary.
I also want to add to it that the barriers for entry for women are not just at the entry level, they are also at the re entry level, they are also at the career progression level, and these barriers are multifaceted and overlapping in nature, right? And there, apart from that, adding to it is the layer of societal sanctions that gender the division of roles. There exists a gender division of roles that makes women meddled in the everyday churn of childcare and chores, which make them indulged more in it, and taking them out, for them having the courage to get themselves out and then bring themselves to a very hostile work culture like the judiciary and the law machinery is, it's very difficult. So the career progression is also quite marred in this regard, especially given the male dominated nature of our judiciary, right? um, okay, we'll go on to talk about as Abhishek rightly mentioned, that there are certain provisions of the collegiate system, the appointment systems, that affect women disproportionately. So, what such provisions are there that affect women directly and indirectly, which often tends to even exclude women? And if we are to have a gender-sensitive appointments policy, uh, firstly, if you agree that whether or not can we have a gender sensitive policy, and if so, how would it look like?
I have already mentioned that there have been certain provisions, not exactly provision. Provision is quite a strong word, but there have been certain cultural practices that I would say that have been followed that has impacted the presence of women in the legal field, their disproportionate presence. So the factors that might follow quite well can be the visibility in the constitutional litigations, like how often women represent the clients in the constitutional litigations, because constitutional litigations is what makes them more known among the judicial fraternity. So that is how they get more promoted towards the higher levels, and at the even to the judge post and all. So that might be one of the factors that does affect.
Secondly, the senior advocacy networks. How many women are more connected to other senior advocates, and how much networks they have. But this is not completely entirely the fault of women, but there might be something because they are already hesitant to expand their networks because there is always a sense of insecurity while colluding with other senior advocates, as they're mostly males. So there might be a sense of insecurity. I must accept that, but that can be another factor.
Right.
Secondly, as I said, the transfer and mobility expectations, because they have family location constraints, spousal employment, child education, etc. So conclusively, I would like to state that women do enter the system, but the system does not elevate them proportionately. That is the standing issue over here.
Right.
So it's not entirely system at fault. It's not entirely the women at fault. If there is certain understanding between women and the system, that does sound like quite a personification of the system, but it should be working like that. So
Right.
that might help in.
Right, and let's not also forget that there is a critical age window of 30 to 40 where women usually move out of the system, which probably is due to marriage or pregnancy or other such societal responsibilities maybe of women. But this is also the critical time where judicial entry for women is possible.
Yes, I would like to say that this collegium recommendations, this is very uncertain. It does not have any clear criteria on what ground the recommendations are made, and also there is a lack of accountability and the expectations on gender balance. Also, we have not yet had any chief justice from us women. So this is also, I mean, 75 plus years have passed since independence, and there hasn't been a single female judge. That is very
Yes, difficult to digest. I would surely
difficult.
agree.
Yes, it is.
We'll go on to talk about are there certain age and experience related rules that affect women differently from men? Can there be reforms that can be introduced to deal with the career breaks that comes due to marriage or pregnancy or other related responsibilities? I mean, I'm sure age is quite a concern because I would like to add that there exists a structural discrimination in this regard. The average age of male and female justices at the Supreme Court and at the High Courts are quite different. This translates to differential tenure for male and female judges. I mean, I can begin surely with the case of the first women CGI who is to be elected by 2027, Justice B.V. Nagarantha, who is going to serve only for a very brief period of 36 days. So I'm sure age and experience rules has a lot to do.
In the district judge recruitment, in the direct recruitment, across most of the states, the eligibility conditions broadly, they are minimum 7 years of continuous practice as an advocate and minimum age of 35 years. Upper age limit usually it is usually around 45 to 48 years with relaxations varying by state. On papers, these are gender neutral, uniform, merit oriented provisions. There is no explicit exclusion of women. This is important to acknowledge upfront. But the typical male career trajectory in this pattern is the law enrollment, continuous practice, minimal long-term breaks, mobility driven by, primarily by career, then 7 calendar years. This should be, the 7 calendar years should be, replaced by the 7 effective practice years. That can be a significant move towards it. The 7 calendar years might not add up to what their experience, because the 7 years is obviously put up to enhance their experience in the judiciary through the litigation, because that is where the person is more exposed towards the system. So the 7 calendar years should be replaced with the 7 effective practice years. Now, if you talk about the typical female career trajectory in this pattern, they are most likely to include the career interruptions due to pregnancy, childbirth, early child care, elder care responsibilities, and other factors might include geographical relocation after marriage, periods of non-appearance practice like research, drafting, chamber work. So therefore, 7 calendar years. Hence, this proves that the 7 calendar years are not equally significant to the 7 effective practice years. So, but the rule only counts the time, not the engagement. So that is one thing. But these breaks are not neutral in practice because legally a break is treated as loss of seniority, loss of courtroom exposure, loss of continuity for eligibility. But in reality, these breaks are structurally predictable, not individual failures. They are tied to socially assigned caregiving roles, and they are not indicative of reduced competence. So the rule unintentionally penalizes predictably the gendered life events, compresses women's eligibility window, forces many to choose between early motherhood or, what we call judicial ambition. So this is what is meant by disparate impact. So no discrimination, but differential burden.
There clearly exist infrastructural deficits in our systems, in our judicial systems. Um, it is undeniable at this point that infrastructural deficits do exist. Uh, there are no separate toilets for women, not even separate retiring rooms. Creches in the court complex is seen as a privilege. What kind of infrastructure do courts provide for to women judges and lawyers? And how does the lack of these facilities push women out of the profession?
Okay, so if we just restrict ourselves to female judges, then absolutely I'll say that there is an infrastructural gap which needs to be filled because the courts actually very disproportionately built. I mean, they are just built for like, for example, when I visit the courtrooms, I often see that the female judges have to sit there, and if they ever want to leave the courtroom and just want to refresh themselves, so they have to travel like all the way back to their chambers.
Right. I would actually agree. I think that these buildings do speak, and they're speaking that, hey, I'm exclusive. Hey, I'm designed for an able bodied male. It's not for you. The buildings do speak. It appears as that.
I suppose the judicial infrastructure in India has, historically been designed around case disposal, courtroom availability, judge strength, digitization, etc. The infrastructure is treated as a neutral physical requirement, not as a human-centered workplace design. So if there is an implicit assumption. They just assume out of it that if a courtroom exists, the professionals will adapt. It does not, reality does not work that way. It does not work on assumptions. So the actual experience that goes on, that courtrooms are not just buildings, they are workplaces, they are long hour environments, high stress public spaces, often poorly regulated after hours, and all these. So the women experience these spaces differently, not because of weakness, but because safety risks are asymmetric and biological needs are non-negotiable. Caregiving responsibilities do not pause for code schedules. So this is where the issues arise. We cannot only work on assumption that the professionals have to adapt, and where the work exists, where there is a work, there is a way. This is what the assumption is.
Right.
They don't even go on the will. They're not willing to go on the will. So there's many women judges, especially in the district judiciary or outstation posting, face issues like delayed allotment of official residences, insecure or poorly located housing, lack of transport connectivity. It impacts by through their reluctance to accept postings from far from family, pressure to seek transfers early, and slower career progressions. All these things impact the even the judicial work and the conditions of women. So it is a concerning issue.
Right. It's been 5 years since a centrally sponsored scheme was devised for infrastructural development of the subordinate courts, which essentially focused on court halls, resident units, lawyers' halls, toilets, digital rooms. But the progress has been very slow. but we are still hopeful, right? Infrastructural audits and real-time reporting are likely to change the neutral nature of these infrastructures to a gender-friendly, especially female-friendly nature, right? And we are hoping that the systemic neglect will soon end. Um, Beyond infrastructure, we also see that there are certain issues within the courtroom ethics, such that inherent lacunae in the courtroom culture exist that tend to reinforce gender biases. How do you think that sensitization can be done, and the courtroom spaces can be made more gender inclusive? I mean, for instance, I can think of uh, casual sexism within the courtrooms that are very likely to happen. I do not have any first-hand experience in it, but you guys as lawyers might have had been at the receiving end of it, or as a bystander, you might have heard of it.
You see, the topic of inherent biases, if we talk about that, when we speak of inherent biases, it is not just prejudice, it is a pattern behavior in courtrooms, especially I'm talking about. In courtrooms, it is a pattern behavior. We are not alleging conscious sexism. We are describing, repetitive behavioral patterns that operate below intent but above accident. Right. So these affect the authority, credibility, and professional standings. What happens is that women advocates are interrupted more frequently by the opposing counsel, as much I have experienced. Sometimes by the bench. The interruptions occur mid submission, before a point is fully developed, or at various instances. It matters because the oral advocacy, it depends on continuity, narrative building. The repeated interruptions, they fragment the arguments. They project uncertainty and reduce the perceived command over the case. That impacts the presentation. Structurally, it affects the women because it makes the women to overall speak less. This affects the client confidence. The briefing decisions, the courtroom recall. This bias is not against the women. It is toward a certain type of dominance. Historically, that is associated with men.
As my friend already has stated, there are some behaviors which persist, which are not, which are a habit of like addressing male judges with greater deferences and interrupting female judges more frequently and questioning their competence, and so this just undermines the judicial authority, and this thinking needs to be changed, and this behavioral aspect of this behavioral aspect that a female judge is less competent than a male one is needs to be changed.
Right. Thank you for highlighting that. Because of the remarks that are made by certain of the practitioners, the whole question of the suitability of women does come under question. It does not come under question automatically, but these remarks put women in a fix, and it actually goes on to kill aspiration. I would also want to highlight that there exists some attributional error of outgroup homogeneity, which tends to project women as emotional and not rational. That all women are same and all women are emotional, and thus they are more suitable to do certain jobs. They are more suitable to do within the law field. They are more suitable to look up and take up disputes related to families, dispute related to domestic violence, all these kinds of issues they are more suitable to. And thus, due to this in-groupism, women judges are labeled as judges who will take up pro-women judgments. And a certain pink collarization of their work is done, which pigeonholes them into a certain capacity, into a certain capability, which when women judges don't subscribe to, they are uh, they are questioned. For instance, I can think of Justice Indu Malhotra, who in the Sabrimala case, she was the sole dissenting judge, and she actually chose to take up that essential religious practices have a primacy over constitutional morality in this context, right? She being a female judge, and she was questioned in certain groups for this, for her anti women, quote unquote, judgment, anti women stance, to be precise. So, this pigeonholing of women and their capacities is also quite a concern that actually emanates from the courtroom culture, the culture that tells women that, see, you have to do this, right? We'll go on to talk about, is there any scope for lateral entry of women as judges in this field of work? And does it exist already? And if not, can it be explored?
In the judicial institutions, the lateral entry does not mean what it means in the bureaucracy or the corporate governance. In Indian constitutional framework, the judges cannot be appointed mid-career for unrelated fields. So the judicial authority is tied to adjudicatory experience or legal practice. So the lateral entry cannot mean the direct appointment of academics, policy experts, or civil servants, as it happens in the governance, bureaucracy, and corporates. But any reforms they must remain within the constitutional purview. So the existing form of lateral entries that is often overlooked is the direct appointment from bar to high courts. There is a system where advocates are directly appointed as judges. So that is the most significant existing lateral pathway. The constitutional position is that Article 217 it permits the appointment of advocates with 10 plus more than 10 years of practice, and it does not require any prior judicial service. This is technically purely lateral entry, as far as I can think. And the gender relevance in here can be that women advocates are also eligible. It is not a gender biased provision. Any advocate who has been practicing for more than 10 years can be appointed as a judge. But the women are disproportionately underrepresented in such appointments. Why? It is not an issue of eligibility, but it is because of as we have earlier discussed, we can conclude from there that there is low visibility in the constitutional litigations and informal collegium consultation process and network heavy identification, as I've already stated earlier, that women tend to have lower level of networks. Also, there is limited senior designation pool. So lateral entry does exist in the law. It exists in the system, in the judiciary, but it is not in effect that much. Also, there is another way lateral entry can be the fast track promotion from the lower judiciary to higher judiciary. That is a quasi-lateral, but not truly lateral. So some states allow the accelerated promotions of meritorious judges. This also benefits women already inside the system, but does not help women outside from the judicial services. And it does not even addresses the mid-career entry. And another provision is that of the ad hoc judges or the additional judges. These appointments are temporary and often used to manage pendency. They can function as testing grounds, where we can experiment things, but the selection still depends on the same informal pipelines, and rarely it is used strategically for diversification. Although what does not exist is that there is no structured lateral entry from academia or policy that as already exists in the bureaucracy. So that is a thing, but the system does have the ways, but they are not truly in effect.
Right.
That is.
Right. I'm sure I agree with you that this method can truly be explored. Apart from that, in appointments, affirmative actions has gained for ground, such that several states have introduced reservation for women in the subordinate courts, particularly Telangana, Assam, Rajasthan. As case in point, what has been the impact of these quotas on representation and public perception? Has this course correction really been fruitful for women in general in the subordinate courts?
With that issue of the reservation in the lower judiciary, we can say that states like Telangana, Assam, there is 30%, 33% reservation. It shows the rapid increase it has been showing rapid increase in women judges. There has been a positive impact of that, and there is no decline in the performance indicators, and greater public confidence is there in the family and gender cases. But as we have already stated that women have been primarily considered as more emotional than practical, so they are already being considered more suitable for the cases relating to family and those type of things. But it has been a thing. So
Right, course correction has worked for the lower judiciary, but can we also trace some other methods that increase the visibility of women in the court? That can we change? Can we bring in some criterion change? Because this affirmative action policy is not reliable in the long run, one, and two, it is not reliable for the case of higher judiciary, because one, the whole system of appointments is clearly opaque and it's not merit based, and thus this system, this policy holds no ground there. So, can we also explore new methods, new approaches to increase visibility of women?
There are some ways through which we can increase the female representation in the judiciary. For example, in the higher judiciary, basically. For example, the direct recruitments are held, right? And that is why the lower judiciary or the subordinate courts have the highest constitution of women in judges, right? So, if we really want high representation, or if we really want to show some better representation, we should increase the lateral transfer of sorry, the promotion of judges, right? As this is like a very big problem in our judicial system. There is hardly any promotion, and all the high court judges that are there are basically those who have been practicing for a huge, so many years that their practice is, they have a very good practice. So they are promoted as judges, and not those who have already recruited as by the direct recruitment. So this is a very basic thing that we can do in order to increase the representation.
Right. I was wondering on this particular question myself. Yes, there can be sensitization trainings. Yes, there can be digitization and development of VC cabins. Yes, there can be virtualization of courts at all levels. But on a different tangent, I was trying to look up what incentives can be provided. So, can incentivizing cases women do take up per year, or annual net annual increment in the cases per practitioner, per women practitioner, if by incentivizing those, can we bring more women into this field, and can we increase their visibility? I was wondering on those lines, but it's still in the formative phase in my head, and it has to. I have to look more on it. I have to process more on it to be able to make a comment. Right? We have been discussing in quite lengths about increasing the representation of women in these courts, but does having more women judges actually change the way courts decide cases, or does it have no other impact than bringing a balance in the gender representation?
yes, women judges can sometimes change the outcome because as we have seen as in the courts that they have more more victim sensitive reasoning. Women they have a better articulation of the family and child right cases. They are not lenient. I'm not talking about that. They have a contextual justice, a sense of contextual justice. Women possess that thing. It's not about the prejudice, but they do have that sense of contextual justice, which can be used in reforming the you know delivery of justice in a few ways. There have been certain myths that women judges are pro women. It is up to some extent mostly false because gender does not predetermine the ideology, and it is a very nuanced experience. I'm sorry, observation, but it is a sort of thing that people say that women are more pro women, but it is not always correct. And more women are People say there will be more convictions. They are more tend they more tend to convict the accused more quickly. It is not always the case. Conviction rates are not reliable indicator of judicial quality or sensitivity. And also, women judges, as you have already said, that women are mostly considered to be more emotional than practical. This is empirically and absolutely untrue, false. It is, and analytically, it is a very lazy observation.
Right.
Anyone who has done that.
Right. I'm sure we all agree that women do bring emotional intelligence, a kind of sthit prajna to the system, but that's not all. That's definitely not all. There's a lot more. And every women judge is also at par, right? We'll close with our final question, which is what can India learn from countries that have successfully increased women's representation in the judiciary, both in terms of numbers and in terms of influence on jurisprudence?
Well, I would like to take this one, as I've already stated that geopolitics is my field of interest. There have been certain practices in other countries like UK, Canada, parts of Europe, and what they did is that the judicial appointments, they have moved from being opaque or reputation-based selection to published competency frameworks. Like we have already stated that a collegium system in the India, it does not have any published framework or structure that it follows to appoint the judges. Rather, in UK or Canada and other parts of Europe, there is a published competency framework according to which judges are appointed. And also the criteria that are included in there is the quality of judgments, the arguments, the consistency of court appearances, integrity, and what we call the temperament, demonstrated legal reasoning. More importantly, the gender was not a replacement for merit in these cases. It was a lens to detect the overlooked merit. What India can learn that India's collegiate system is not problem is not the secrecy alone, but the reliance on the informal reputation, narrow professional networks. As I've already stated, women tend to have lesser number of networks, so because due to the sense of insecurity prevailing due to the society and unequal visibility host histories. The lesson that can be learned is that when merit is defined narrowly, it unintentionally rewards the privilege. So a transparent matrix, it allows the women advocates to, with solid records or the first generation lawyers, to become institutionally visible. Also, the diversity tracking in the countries like Canada, Australia, and South Africa, what they did is the judicial systems, they track the representation data, that is the applicants, shortlist, and appointments. The data is published periodically. The thing is, the main thing in whatever points I'm stating is the transparency in the India system. They are always publishing the data periodically. The criteria have been published according to which the appointments are made, and the data regarding the track representation data is also periodically published. So it is crucially no automatic quotas and no outcome compulsion. The system simply asks, where exactly are we losing candidates? So this was by making it forces the institutional self-audit. It prevents denial, like there were no suitable candidates. They cannot say that, because there was already some published criteria according to which there will be some. So this can be a thing.
Right. All right. We now come to the end of the podcast here. It was really an insightful experience talking to you, and more so, it was a fun exercise talking about an issue that I'm really passionate to talk about. Thank you for joining in. It was lovely talking to you.